Good afternoon, everyone. My name is Sara Youngdahl, and I am at the Youngdahl Law Firm in Houston, Texas. I have been representing injured railroaders for about 25 years now. So I just tallied it up today and was shocked to realize that it's a long time. I'm so glad that President Siegmiller asked us to be here today. It's very important that if you as an injured railroad worker or you get injured on the job, it's very important for spouses and partners to be involved in the process. The railroad workers are not covered by a workers' compensation scheme. They have a special law that protects your spouses and partners and yourselves, for those of you who are railroad workers watching this. And it's called the Federal Employers Liability Act, the FELA. On your screen, you see here, all of us, the lawyers that are with us today are all designated legal counsel for your union, Smart Transportation Division. What difference does it make to you and your family if you hire a DLC as opposed to somebody that you may know from another case, somebody a family member knows, or a lawyer that you just find just randomly? The important thing about hiring DLC if you're injured on the job is that we here on the screen and some others around the country specialize in exactly what we're going to talk about today. And as you all know, the railroad industry is a very unique industry. The terms, the procedures, the processes, the safety, all of the things that are important to your FELA case, should you be injured on the job, are understood by us on the screen, as well as, again, some others around the country. We won't go into horror stories here today of folks who have hired non-DLC when injured on the job and how that ended up. It's very difficult to get on board and understand the intricacies of the cases, the safety procedures of the laws, the regulations that affect you on a daily basis out there if you're not experienced and not approved by your union for representation. So the FELA, most of you may have heard of that before, and we all here surely hope that none of you, your spouses, your partners get injured on the job. We, like you, want you to go home safely, just as you were when you came to work. Unfortunately, as we've seen, and as you know as well, that the railroad is often not a safe place to work. And so you guys and your spouses and partners have the best law protecting injured workers in the country today. You're not covered by workers' compensation. You're covered by the FELA. The FELA, the Federal Employers Liability Act, is over 100 years old. So it's been tested. There have been hundreds, thousands of cases brought under the FELA over the years. So what is the FELA and what do you have to show when you're injured on the job? Under the FELA, we have to show as your counsel that the railroad was negligent. So lawyer term, negligence, you may have heard that term. What does that mean? To show that the railroad was negligent, what we have to do is to show that the railroad failed to do something that they should have done and failed to enforce their own safety rules, failed to follow their own safety rules, failed to follow federal law regarding safety on the railroad. In addition to the FELA, there is also other laws that protect your safety and your loved one's safety on the railroad. First, we have the Locomotive Inspection Act, which is another safety law regarding the condition of locomotives that you often have to work on. you know, your partners and your spouses know as well as we do that the locomotives on the railroad are not always kept in tip-top condition, shall we say. So we've got all kinds of issues there. And the Locomotive Act says that's not allowed. The locomotives and their parts and appurtenances have to be kept in safe condition. So that is an addition to the FELA, another law that protects you should there be a defect on the locomotive that causes your injury. Secondly, there is the Safety Appliance Act, which is much like the Locomotive Inspection Act, except that it applies to rail cars. So, for example, we're talking about bad order brakes and other parts on the rail car that may be involved in your injury. The powerful thing about the Locomotive Act and the Safety Appliance Act is that if one of those is proven in your case, it results in what we call strict liability. So strict liability is another fancy legal term for your fault is not considered. That means the railroad is absolutely liable, absolutely negligent, and the railroad can't come back to you and say, hey, Mr. Jones, it's all your fault, because those two laws protect you against the railroad blaming you for negligence. Under the FELA, if you have a straight FELA case and you don't have a defective locomotive or a defective rail car, it's a comparative negligence situation. So, for example, if the railroad is 50% negligent and you are 50% negligent, then your damages would be reduced by 50%. One thing that's different about the FELA, as opposed to workers' compensation that covers other types of jobs, is that the FELA is a fault-based statute. So we do have to prove the railroad's fault. It's not automatic. A lot of people think you get hurt, it's automatic. Now, don't get me wrong, it's not too difficult most often to prove that the railroad did something wrong. But we do have to show that. So that's definitely an important feature. So those are the two laws, the strict liability, the Safety Appliance Act, rail cars, the Locomotive Act, locomotives. In addition to that, the government has a whole set of regulations that the railroad has to follow pertaining to many areas of railroad safety. And just from this brief introduction, I think that folks should be able to tell that it's a very specialized practice. And that's why we urge you to, if you're injured on the job, we urge you to hire designated counsel approved by your union and specializing in this specific area. Because if you don't, you may result in a situation where your attorney or your lawyer may not be able to figure out all the ways that the railroad is negligent, which means at the end of the day that your damages may be reduced because the attorney did not specialize in this area. So not trying to make an ad, not selling here, but we've all on the screen see what happens when a non-designated counsel represents an injured railroad worker and later says, oh, I should have hired GLC. So instead of being sorry that you didn't, just take the proactive step and do that. I'm going to pass my time over to Mr. Matt Darby. Thank you.
Thank you, Sarah. My name is Matt Darby, and I'm the principal in the Darby Law Group. We're based in Baltimore. And Sarah, thank you very much for that explanation of sort of what we might characterize as the liability part of the FELA, or proving an entitlement to recover. As I tell clients, and I'm sure other lawyers say similar things, the railroads are going to defend the case on every possible defense that they can. And one of those defenses is what we call as lawyers causation or medical causation, and the other element is damages, because we don't want to be in a situation where we prove the railroad was responsible for an injury or an incident, and that the injured railroad worker wasn't responsible, and then not be able to recover damages, because at the end of the day, that's really what the case is about. The law is designed to make sure that the injured railroad worker is compensated or made whole in light of the injuries. And so two areas there. When we talk about causation, what we mean is that the railroads are going to say, look, if we were responsible and the injured worker wasn't, whatever claim the injured worker may be making with regard to the nature of the injury is in dispute. And they're either going to say that they weren't injured, or that they weren't as injured to the extent that they're claiming, or that the injury is really due to pre-existing conditions. So there are a couple things that need to be done initially, just to make sure that when we're standing in front of a jury, if it comes to that we don't have to explain a bunch of things. And so it's important to make sure that medical treatment is sought right away. A lot of times, railroad workers are coming, oh, I thought it was going to go away. I didn't think it was going to be any big deal. And so they delay in getting medical care. That's a big mistake, because at the end of the day, those records of medical treatment are going to be central in this causation issue. And we need to make sure that the medical treatment is consistent. And that means going to the doctor right away, giving a clear history about being injured on the railroad, and making sure that the injured worker lists any body part that may be impacted. There may be an acute injury and a more seemingly minor injury. And at the end of the day, that more minor injury becomes more debilitating. So we need to make sure we mention all body parts, and we need to make sure that we follow up with the medical treatment recommended by the doctor, so that at the end of the day, the injured worker can't be criticized, or there can't be any innuendo raised by the railroad that the injury, didn't happen on the railroad. One of the big things that we deal with in this regard is pre-existing conditions. And it's not unusual that we have a client who injures his or her shoulder. They come in and they may have had a pre-existing shoulder condition, or any area of the body that's injured. And it's important to be clear and not try to hide that, because the railroad is going to find out about it. We can deal with it if we know about it. It's important for us as counsel to know. We can deal with any of those things, because after all, whatever that pre-existing condition may have been, that railroad worker was out there doing a very heavy job despite that. And so we don't want to create a credibility issue if it looks like there's some effort to mask that or hide any kind of pre-existing condition. So you always want to get medical treatment, list all the body parts, follow up with what the doctor says, and tell the doctor about any pre-existing conditions. Then what happens is, depending on the nature of the injury, the damages are going to consist of two things. One is what we call economic damages, and that is typically going to be lost wages, and non-economic damages, which is the concept of pain and suffering. So one of the things that makes the FELA unique in what would otherwise be a workers' compensation type law is that the jury, and juries decide these cases, ultimately the jury can make an award on pain and suffering. And so where you can add up wages, if the injured worker goes back to work after their treatment, it's very easy to figure out what those lost wages are, almost to the penny. Pain and suffering is different. Pain and suffering is the concept of mental anguish, stress, all those things that go into pain and suffering. And I'm sitting here with a recently operated Achilles tendon injury, and I can tell you a little bit about pain and suffering. But it's important to document all that, and to make sure that it's understood and clear, so the employee doesn't go in and try to be a hero and say, oh, I'm fine, I'm doing really well. Most injuries that happen on the railroad tend to be serious and leave employees with some residual problems. I always tell clients, you don't want to be a hero. You want to make sure you tell the doctor exactly what the problems are. The more challenging cases come in when the employee is going to be disqualified from going back to work because of the nature of the injury. And that's not unusual. We deal with those cases quite a bit because, again, the injuries tend to be serious and the work is difficult. And so a word about that. In cases where an employee can't go back to work, it's obviously a much more life-changing, life-altering type of injury. And in those cases, it's important for the treating doctor to understand the nature of the work. From a doctor's point of view, they typically don't deal with railroaders in most cases. They don't understand what a conductor does, for example. Even on the passenger or commuter rail side, they don't understand what goes into making up the train beforehand, the emergency situations that may arrive, and the physical demands made on the worker. So it's important for them to understand that, and oftentimes, we supply job descriptions, even photographs of the work that our clients do, and so that's an important part of it. On the medical treatment issue, it's also important to understand that unlike a traditional workers' compensation law, the railroad does not have the ability to approve or disapprove medical care. It's a little beyond the scope of what we're talking about today, but under the Federal Rail Safety Act, that is actually a violation of the law. And oftentimes doctors don't understand that. And so if the injured railroader is in a situation where the doctor says, oh, I have to get approval for that MRI, or I have to get approval for those injections, which is a situation I just dealt with this morning, it's important to understand that the railroad does not have the right under the law to approve or disapprove medical care. In situations where the person's disqualified from going back to work because of their injury, then the elements of damages are going to include future lost wages as well as loss of benefits. And it's important to understand that even in a situation where an individual may receive an occupational or total and permanent disability from the Railroad Retirement Board, there is still likely a argument that can be made by the railroad that the employee has what we call a residual earning capacity. So in the issue of future lost wages, typically the future lost wages are going to be, the total lost wages and benefits minus whatever the residual earning capacity may be. And a mistake that we see clients make sometimes is that railroads will send a letter to a disqualified employee that might say something like, hey, we have this vocational rehabilitation program and, we want to help you. Well, the reality of it is they're not really helping. What they're trying to do is hope that you ignore the letter. Because if you ignore the letter, then they can get up in front of a jury and say, we sent this letter to, Mr. Injured Railroad Worker, and they ignored it. And had they not ignored it, we would have put him back to work. The reality of it is that never happens. It's in my 30 some years of representing injured railroad workers, it happened one time successfully. And so we need to know about those letters. We need to respond to those letters to the effect of, hey, here's an employee's been with the railroad 25 years, he lives here, he's established in this, what can you offer him? You had thousands and thousands of employees, and it gets to be like a little bit of a chess match back and forth. But the key is don't ignore those letters. We will need to retain a vocational expert who will address the issue of the residual earning capacity. And so that's an important part of the element of damages. Another issue with respect to in the general category of medical causation, or the railroad's argument that the employee is not as injured as he or she may claim, is the utilization of surveillance. And surveillance can be a very devastatingly bad element of a case that hurts on this issue of damages. And surveillance is just what it sounds like. The railroad will hire a private investigator to surveil or follow the injured worker, to do an activity check or something like that. The downside of it is that very often the surveillance itself isn't that traumatic. Okay, maybe somebody with a knee injury who arguably isn't limping, but what it does do is it allows the railroad to show video that may show the employee's house, you know, a nice car, going to a restaurant, something like that. So we always want to tell our employees that they never go out of the house where they don't appear to be significantly injured, because then it's less likely that the railroad will use the surveillance. We always want our clients that look like they obviously need the money, which they do. And so that's a brief overview. You know, just recognize that winning the case could be an empty victory if we're not successful in showing, you know, that the injuries were caused by the incident and that the employee now injured is entitled to full measure of their damages, including lost wages, pain and suffering, perhaps future lost wages and future pain and suffering. So, so the moral of the story is getting back to Sarah's theme, which is we understand the railroad industry. We understand the tricks that they're going to play. We understand the levels that they're going to fight the case on. And so that's why it's important to have experienced counsel working with the injured worker, you know, really from the very beginning of the case. And so with that, I'm going to turn it over to Chris. And Chris, thank you.
Thank you. I am here today to talk about accident reports, also known as employee injury reports. These are essential in forming the cornerstone of your case. It really starts the beginning of a story, and it kind of gives us as DLCs an outline of how to proceed with the case. So when you are injured, you know, it's very important that one, you notify your supervisor, and two, you fill out an accident report. Every railroad has them. They vary, you know, from railroad to railroad. Some railroads have trick questions. Some railroads have a more general form. I practice out of Boston and New England. For Amtrak and Keolis, they have a more general accident report, which essentially outlines, you know, the time and date, the weather, and then for the employee statement, you give a description of how the accident occurred. And as Sara touched on, under the FELA, it's different than a workers' comp scheme, which is no fault. Under the FELA, we have to prove some negligence on the part of the railroad. Courts have deemed this to be, however, slight, but there has to be some element of negligence on the railroad, which is often characterized as failure to provide a safe place to work. So when you're filling out your accident report, it's essential that you fill it out properly, you fill it out timely. You never let a supervisor fill it out for you. Oftentimes supervisors or management will appear in the emergency room. If it's a very serious injury and you're under the influence of morphine or any sort of pain narcotic that would impair your ability to give the report, don't sign the report. So don't let the supervisor fill it out and say, oh, you know, here you go, this is what happened. Because what happens is the accident report will become Exhibit 1 in your deposition. And a poorly filled out accident report can be devastating to a case. For example, I will share with you a CSX accident report. Okay, so on CSX, on the top, it has your general information regarding your employee name, time and date, weather, treatment, a description of the incident. And then on page number 2, excuse me, at the bottom of page number 1, it said, did it involve a defective tool or equipment? Now, if you're working with a piece of equipment and you're injured, put yes. If you put no, then you kind of box your attorney in terms of how they proceed with the case. Because at your deposition, they'll say, well, you said the tool wasn't defective in your accident. In addition, CSX has kind of some sneaky language on page 2 of their report, which says, did the employee have a safe place in which to work? Now, if you click yes, you are essentially saying that CSX provided you with a safe place to work and that they did nothing wrong. And that really is not always fatal, but it can be very difficult for the DLC representing you if you say you had a safe place to work. You know, the BNSF, which I don't deal with very often, has a particular part of the form that says, could you have prevented your own injury, yes or no? So if you click yes, and then it says explain, I could have walked around the hole, or I should have been walking slower, or oh, I knew that that was defective. These are questions you might not be thinking about in the moment because you're injured, but they're really a trick question that will make your case extremely difficult down the road, particularly for the Class 1 freight railroads out west. After you fill out your personal or employee statement, then your supervisor fills out a statement, and then all of those get generated into a more comprehensive accident report that is then put together by somebody who has no knowledge of the accident at all. So you want to document witnesses, the parts of your body that were injured, any inclement weather, and sometimes brevity is key. So you don't want to overthink it. Sometimes you might not know, or we might not know exactly what happened until we get into discovery and we depose co-workers or witnesses. So documenting those co-workers and witnesses is very important, and that will identify to us how to notice depositions going forward. Another common theme is obviously no one likes to blame a coworker for their accident. However, if you get run over by a piece of equipment, you know, the operator of that equipment is probably responsible. So, you know, some of the accident reports ask, was another person responsible for your injury? So really, you got to be careful about not binding yourself into a story that later might turn out to be difficult to prove. So sometimes vagueness is better. If you don't know, you don't know. Write down failure to provide a safe place to work. Essentially, on our complaints, you know, if the case can't get settled with the railroad before trial, or excuse me, if the railroad will not settle it, we'll have to put the case into suit. And I call it the hit list, you know, where you allege what acts or omissions the railroad, or you outline their negligence, and we'll say failure to provide a safe place to work, failure to properly train, failure to provide an adequate safety briefing, failure to warn, failure to maintain, failure to inspect, OSHA violations, and down the list, failure to provide adequate tools and equipment. And the majority of the time, one of those will stick. Failure to provide adequate lighting. I know that when you fill out on the report, CSX says, was there adequate lighting? You know, so if it's nighttime and you're injured in a trip and fall, you know, you want to answer no, it was not adequate lighting. Just remember that your personal statement in the accident report is going to be crucial. It's going to be used as an exhibit in your deposition. The railroads use trick questions in them that may not be obvious to a non-lawyer, but they're really, from the moment that you get injured via the accident report, the railroad is really establishing a defense to a potential FELA lawsuit against them by you. So that would be how you should be thinking about the accident report as evidence in your case going forward. I know that Mark after me is going to talk about statements. Amtrak will often augment or use as an addendum to their accident report a recorded statement. I recommend to never give them a recorded statement. If you have an attorney already, tell them you're represented by counsel, but don't ever give them a recorded statement. The less you give them to use against you down the road makes the DLC's job a lot easier. And I think on that note, I will hand this off to Marc Zito.
Thank you, Chris. I'm Marc Zito with Jones and Granger Law Firm in Houston, Texas. As Chris said, exhibit number 1 is the accident report in your trial. Exhibit number 2 will be the statement that you give to the claims agent in your trial. And if you compare, maybe some folks are familiar with statements that an insurance company takes in the case of an automobile accident, but they're not the same thing. Okay, they usually, well, from what I've seen, the written statements or recorded statements that insurance company agents take in automobile accidents are very short. They're like 15 minutes. They ask a few basic questions. Well, it's not the same with the railroad cases. The railroad claims agents are by and large trained by their counsel, by their lawyers, by the railroad lawyers. They regularly attend meetings. They know how to ask leading questions, which are not questions at all, but are just simply statements that ask you to agree with. They know how to ask innocuous questions, that is, questions that to you don't seem important, but are very important in your case. And then, you know, they make you feel like they are your friend and they're just trying to help out, which of course is not true. The default position, if you're the injured party, is to not give a statement. Although sometimes if you're trying to work a claim out yourself without counsel, I know the Union Pacific Railroad won't even talk to you unless you give a statement. So it's important that if you do try to handle a claim yourself, that you get some legal advice from one of the designated counsel about having how to give a statement. Because remember, after an injury happens, by and large, you're usually in the fog of war. Injuries can be confusing, they're stressful, they're costly, they're time consuming. People get emotional during this time in their life and they say things that unintentionally can hurt their claim, or they don't understand the legal nuances of a question and the ramifications of their answer. So generally speaking, the claims agents will ask for a recorded statement. What happens is as soon as you report your injury on the prescribed accident report form, that goes to your supervisor, and then it generally goes to the claims department with the railroad. And those claims agents are immediately told to contact you and try to get a statement. The reason they want to get a statement, of course, is to put all of the fault back on you, to at least take the fault off of themselves, put as much of the fault as they can back on you. And then when you get in trial and you testify differently from your written statement, they're going to use that to make you look like a lawyer. So you have to remember that any information you provide them can later be used against you. The written statement can be introduced at trial. It can be played at trial for a judge and jury to listen to. And then if there is any contradictory later statements, or if you state you weren't injured at the time of the accident, or if you said it wasn't anybody's fault that this happened, or it's just one of those things that happens, this can be construed by the jury to take the position that you are a liar and you're trying to defraud the company. And the railroad argument will be, at least in terms of the Union Pacific Railroad lawyers, you're trying to win the UP Lotto. And so even if you develop injuries over the next several days, the jury will hear that initial statement, which can cause doubt to anyone that's trying to determine if you should be awarded a settlement or any settle amount for your monies. So make sure that you get advice, that you do not walk in to the statement by yourself without getting any legal advice, because most of my experience is with the Union Pacific Railroad. Those claims agents have got a book about the statements. I mean, it's pretty thick. It's page after page after page. They're told to ask these questions in exactly this manner and in exactly this way. And it can go on for an hour and a half or longer. Okay. Well, those questions have been prepared by the railroad's lawyers, and they're prepared for simply one reason, and that is to hurt your case and help their case. Okay. So these recorded statements generally are very damaging. I've seen some where it just it shocks your mind that somebody answers that, and so if the claims agent asks a question like, well, this is just one of those things that happened, isn't it? And you go, well, yeah, I guess it is. I mean, if you're not experienced, that you don't know the importance of the answer to that question, and you're answering probably honestly, it's just one of those things that happen, but that is going to be used against you at trial. And that is going to be used to establish that, hey, he said right after this accident happened, right after he was injured, when things were freshest in his mind, he got up on this, he came to the claims agent office, or the claims agent came to him, and he took a statement and he said, just one of those things that happened. I don't know anything that was wrong. I can't say there was anything unsafe. I wasn't paying attention. People say all kinds of things that, hurt their case. So it's really important that you always get legal advice before you give the statement. And, even if you don't have a lawyer and you're going to do it yourself, there are, on this screen and at the Smart TD website, there are a lot of designated lawyers that you can call, and you can go over your injury, and they can help you give the statement. They can tell you the kinds of questions that they're probably going to ask and what you should answer, and they can certainly tell you things not to answer. So take advantage of the advice that we're providing, and consult with an experienced designated attorney before you give a statement, so that we can explain your rights, your benefits, your options in the beginning, so that you can be fully informed about the best way to handle your case moving forward. Now, if you are a witness to an injury, in those cases, you most likely have to give a statement. I tell people, yeah, if the attorney or the claims agent comes and wants to talk to you about how your friend got hurt, you probably have to answer those questions, but you don't have to offer opinions. You can just say what you saw, what you heard, whatever your own senses are, just the facts, and not give any opinion. So if the claims people ask you, well, in your opinion, was the job being done safely? Was the equipment safe? You can say, look, I don't know about that. All I know is that I saw him fall, or I saw him grab his back, or I saw something happen. Just the facts, not any opinions. And that would be the best way to handle a statement if you're a witness to an injury. But if you are the injured party, like I said, the default position is not to give a statement. But if you're going to get some advice before you do that, please. I think that's all I have. I'll turn it over to Chip now.
Good morning, everybody. My name is Chip Rabb, although my real name is Lloyd. Everybody knows me as Chip. And I am proud to say that this month, 50 years ago, a half a century ago, I started working as a brakeman for Southern Pacific. This is my 38th year of practicing law, having left the railroad after 14 years. And I'm going to tell you, with the experience that I've got, not only on the railroad, but as an attorney, everything that you've heard so far is 100% accurate, but it's not complete because we just can't tell you everything in an hour. My topic is about the railroad loves you. until they don't. And you have heard that through the course of what everybody has said today, and I think what Mr. McGuire is going to say in just a little bit. The essence of it is, the undercurrent is, the railroad wants employees, but only because they perform service and make profit for the company. Beyond that, they don't really want the employees out there. But the employee, on the other hand, this is a wonderful job. I loved working on trains. I loved switching boxcars. My whole family loved it. It was the company that was the problem. And what the company does from the very beginning of the employee's employment is to protect itself. It protects itself, and everything that Matt Darby, Chris Naumes, Sara Youngdahl, and Marc Zito has said has been designed to explain how the railroad protects itself. And so what you as a significant other, spouse, or an employee must do, you have to do it, is to protect yourself. If you don't protect yourself, the railroad will win. And as Mark said, this is the fog of war when an injury happens. And I suspect your significant other or spouse, or if you're an employee, comes home, you realize this railroad, none of the railroads are out there to help you. You've got to help yourself. I just want to say something about what Mark was talking about on these statements. Employees, when something happens out there, they have a tendency to want to cooperate because they don't want to get disciplined. They want to keep their job. They want to keep working. And so they try to cooperate. And so they want to go in and give a statement. Here's just one example of a question that hurts. They asked the employee, you've been out here for the last 10 years. How long were you planning on working? Were you going to retire when you got retirement age of 60? Many times employees will sit there and say, oh yeah, that's exactly when I'm going to go, first chance I get. If that employee ever gets in a job-ending injury, he or she has just limited his future wage loss claim to the earliest retirement age of 60 rather than extending it beyond that, because we as attorneys can do that generally. But if the employee has limited by making such a statement, those are the kinds of things that Mark was talking about that hurt us. It makes it so that we can't advance something that the employee has already signed off on. That's just one example. Now, if I could, I want to show you, well, let me back up. When an employee hires on the railroad, they feel really good about the job. They really do. They're excited. They're getting into a new industry. It's got great retirement, great benefits, has great opportunities. And I'm going to tell you, there's nothing that's really more satisfying than driving a train across country. Then the railroad, once that employee starts making his date and working, the railroad spends the rest of its time watching the employee. It watches them on video in the yard, watches them on video in the crew rooms, watches them videos in the crew vans. Everything that the employee does, the employer starts watching. Social media accounts. BNSF looks at social media accounts on a regular basis. They have a team that does nothing but watch the videos of in-train or in-cab cameras. Their whole purpose of doing these things isn't to protect the employee, it's to protect the company. And so what the employee has to do, not only after employment starts, but specifically when an injury occurs, the employee has to protect him or herself. And you as a significant other or spouse have to cooperate and help the employee do that, because the company's not going to do it. I'm going to tell you what the claims agent, and the claims agent is part of the law department, what they're going to do is they're going to put their arm around the employee as soon as an injury happens, and they're going to make promises. They're going to say, we will take care of you. Don't worry, we'll take care of your medical expenses. We'll try to help you with loss of earnings. We'll see that you get the proper medical care. All you have to do is cooperate. And if you think in the back of your mind, they're protecting themselves, we need to protect ourselves, you'll be in a much better position. And just what Mark and Chris were talking about, just filling out the accident reports and statements. They said it. Those are exhibits number 1. I'd like to share a screen with you. I'm assuming you can see that screen now. And on it, you should be able to see, here's one way that you can protect yourself, or the employee can protect him or herself by filling out the accident reports. This exhibit, the accident report, will be exhibit number 1. But if you have put on there, I may not be aware of all the facts, I have not investigated the accident and may not be aware of all the facts, at least it gives you some moving room, some wiggle room in the event they decide to hold that against you, the accident report. You can sit there and say, I didn't investigate everything, so I don't have all the answers. And this was right after the injury occurred. And so consequently, I didn't have all the answers at the time I answered those questions. Another thing that I do want to share, because this is important, and this goes to medical records. This is a document I created about 25 years ago. Please copy it. What do they say? Flattery is copying or is the best form of flattery. And I'd like to take the time to read this so that you can all understand it. This is what you give to your doctors. As you know, I'm treating with you as a result of an injury I sustained at work on the railroad. Because my injury occurred on the railroad, it is important for you and your staff to have the following information. There is no state workers' compensation on the railroad. Injuries on the railroad are covered by a federal law which is not related in any fashion to state workers' compensation laws. So you do not need to and should not fill out any workers' compensation forms. Likewise, you should not send any information to the state agency which administers workers' compensation. Medical bills are not covered or paid by workers' compensation insurance. Because injuries are handled different on the railroad than any other industry, workers' compensation does not pay any of the bills. Please submit all bills to my health insurance. Do not submit bills to the railroad. Do not provide any information about me or my medical condition or care to anyone, including the railroad or its medical personnel. The railroad may contact your office for information. I request that you and your staff not provide any information to the railroad. I will provide my employer with any information it may need. That letter has been phenomenal with the people that I have given it to in protecting their interests. Let's get back just to the injury real quick. When an injury happens, the employee and the employee's family has to start thinking immediately about how they are going to protect themselves. The railroad is immediately going to start gathering evidence, and I've taken depositions of claims agents for the last 15 years, and I've asked, isn't it your primary responsibility to protect the financial interests of the company? And their answer is always yes. And so the employee has to do what he or she can to protect his or her interests. And these things that we've been talking about are designed to help do that. And I'm going to tell you, designated legal counsel, not just because I am one, but as a railroader, I saw it as well, did what they could to protect the employee as long as the employee doesn't mess it up. Thank you. I'll pass this one on to Clint.
I'm going to be talking about the effects of precision scheduled railroading on railroad safety. So my name is Clint McGuire, and I am from Houston, Texas. Let's share my screen for a second here. Okay, so we're going to be talking about the effects of precision scheduled railroading on railroad safety. In 1993, the CEO of CSX coined the term precision scheduled railroading. In 2018, Union Pacific Railroad Company had their own name for the same thing, which was Unified Plan 2020. And what that really means is we're going to put profits over people. We're going to make the trains longer and the workforce smaller. And so I thought in giving this presentation and talking about this today, what better way to talk about the effects of precision scheduled railroading than to go through Jeopardy? Because that's exactly what the railroads are doing with precision scheduled railroading. They are jeopardizing the health and safety of not only you, but also your coworkers and the public. And so when we talk about precision scheduled railroading, it's just a real fancy term that the railroad likes to use to sort of downplay the effects of what they're really doing. But when we look at the game of Jeopardy here and the topics, the first thing we start with is mass layoffs. That's the first thing that the railroad really means when they start talking about precision scheduled railroad. Because what they did is they went in and started cutting the mechanical forces. They started using fewer locomotives. They started doing less maintenance. And so the railroad likes to use these terms to sort of soften the blow of what they're really doing. And so precision scheduled railroading, they claim they want to streamline operations. Well, streamlining operations means they're going to start cutting jobs. And so that's one thing that happens when we start into precision scheduled railroading. Now, the next topic that we look at here in our game of Jeopardy is the railroads make the trains longer. And of course, the reason why the railroads want the trains longer is so that they can make more money. It's not safer to do it, and it's not safer for you guys, and it's not safer for the public. These longer trains block railroad crossings, the school buses that need to get through, ambulances or fire trucks that need to get through. Because of the length of these trains, it once again, an effect of precision scheduled railroading is making these trains longer. Now, if we move over to the third topic here of our game of Jeopardy, one of the effects of precision scheduled railroading is fewer inspections. The railroad does fewer inspections of the track. They do fewer inspections of the safety appliances that Sara talked with us about earlier on the rail cars. They focus their efforts not on the actual safety appliances, the grab irons, the handholds, the stirrups of the actual rail car, which are intended for the safety of those operating and using the rail cars, but instead on the couplers that keep the trains together for these longer trains so that they can make more money. And then we move over to another consequence of precision scheduled railroading, which is safety complaints to the FRA. So since 2020, one thing that we have seen is a dramatic increase in the number of safety complaints that have been made to the Federal Railroad Administration because of what the railroads are doing. The railroads, of course, would have you believe, if you go and look at their literature, that precision scheduled railroading is safer, it's more efficient, it's more effective, and that it's actually more safe, they would have us believe. Except for that's not what we're actually seeing by the people out on the ground. And if you want to know what's going on the battlefield, you go to the people that are there that have bullets whizzing by their head. And so in this particular case, what we've seen in 2020, there were 200 FRA complaints. It jumped to over 500 complaints in 2021. And the last I saw through July 2022, the complaints were up over 700. And that's a direct result of precision scheduled railroading. Finally, as we're all seeing on a daily basis now, one of the effects of precision scheduled railroading are train derailments. You cannot expect to cut back on labor. You cannot expect to cut back on maintenance. You cannot expect to cut back on your budget and then not expect there to be more derailments. It is a direct link. You cut back on inspections, you cut back on your crews. One thing you know for certain that you're going to have as a railroad is more derailments. And so with every game of Jeopardy, the very end of it comes down to the final Jeopardy question. And the final Jeopardy answer here is $16 million. And if we sat around and listened to the music, we would know that at the very end, the answer to that question was, what was the minimum salary of the 5 major rail CEOs in 2021? Because once again, precision scheduled railroading is not about safety. It's not about being precise. It's not about being more efficient. It's not about streamlining things. It's about one thing and one thing only, and that is the railroads CEOs putting more money in their pockets and getting more money to their shareholders. So when we see, as we do almost nightly on the news now, another derailment that not only jeopardizes the safety of the train crew, their co-workers, but now also the environment, our drinking water, the public, then one of the things that we have to thank for that is precision scheduled railroading. We should get back to common sense things like making sure that when we're transporting freight, that we really are concerned about safety and that we don't try to put these catchy names on it to deflect from what we're really trying to do, which is to do more with less so that we can make more money. So I echo the comments that everyone has made here earlier. This is a great panel to be a part of. If something happens to you, you should do exactly what it is that each and every one of these guys have told you about earlier. Thank you.